All right, just to let everyone know that we are being recorded and we are live on YouTube. Yeah, so.
All right, so I'm sort of looking into a black box, Alfred. Do we have the assembled people, or they just can view us through the YouTube?
I can see everyone's here. I think the people are just going to pop up into your screen as they talk. So like,
Oh, yeah.
I'm talking right now, so you can see me straight away. So,
Right. Thank you. So, welcome everybody. This is a resumption of the Plan Change 2 hearing, and it has the specific purpose of considering the additional material that's been supplied by the Mansells following our direction for further information. And of course, we have read it, and we're likely to have some questions, but I think I should hand it over to Ms. Tancock to just sort of tell us how she wants to run it, and what procedure she'd like to follow.
Brilliant, thank you, Sarah, and thanks to the panel for giving us the opportunity to reconvene to have a discussion on this. I guess I was conscious, firstly, of the fact that the panel had previously issued a minute saying that if there was expert evidence being provided, that there needed to be an appearance in case there were questions. So the main component of today, I think, is a quick run through of some of those, some of the material provided. Particularly Mr. Hansen has travelled across quite a broad range of material, and I thought it might be worthwhile having that, having Mr. Hansen talk you through that. Today we also have a very brief statement from Mr. Mansell, which would have come in, and I was hoping that Craig Martell from OUR was going to join us today just briefly to talk to his memorandum, and I'm hopeful that he's just a little bit late. So I guess if it's okay with you, I've got a few points to make about some things, and then I might hand it over to the rest of our witnesses.
Thank you.
Okay, so I had filed a memorandum, and I'm just going to note, obviously, Mr. Mansell will speak to the submitters. There was a little bit of assumptions around what he may not do in relation to the existing Otihanga consents that are appealed. So you'll hear from Mr. Mansell on that point in a minute. We have also, in response to the council's concern that the land to the north of the Mansell site was infrastructure locked, didn't have access and may have difficulties providing services and things like that. The Mansell's property lawyers, Duncan Cotterill, we filed a memorandum on behalf of them. They had done an access and easement and services check for all those properties. I don't intend to take you through all of those. I'm hoping that was pretty clear and has been read. There's a very useful map at Annexure 1 of that memorandum, which shows all the sites, and they confirm that there's different road access or right-of-ways for accessing vehicles and stormwater and electricity and all those things. So that was just to provide some context around council's concern that there may be that development of the Mansell site may preclude the ability to access those sites. And you'll see, while on the Boffa-Miskell map, it looks like a lot of different sections. There's a commonality in the landownings there, which mean that a lot of those blocks are quite large and are owned by one party, and they go all the way through to the other existing residential area. So if the panel has any specific questions on that material, I'm happy to take those back to, or I'm happy to try to answer them, but I'm also happy to take those back to Duncan Cotterill and get a written response, just because I'm not going to profess to be a property lawyer or be particularly up on easements and things like that. So just thought I would. Were there any questions on that material?
No, I think it was I think it's straightforward. I probably would ask some questions of Mr. Hansen just around that. But it's helpful to see that how those easements and so forth work, and the fact that it's not going to be landlocked. I guess speaking for myself, and I have to be clear that I haven't spoken to my fellow panel members about it, this site has a number of things going for it in terms of a potential rezoning if it doesn't require a structure plan. And part of it relates to the fact that it is a maroon site following a very large public work that has been subject to quite a lot of assessment and consideration. And it's in scope and doesn't seem to raise the same structure plan issues that other sites might. And I guess what we're interested in is whether, given that there is a conceivable trajectory of land in that area towards residential, whether development of this land in some ways creates a suboptimal urban environment. And that could arise in two ways. The first, because the development occurs in its current form and then has this residential overlay, which is an odd, to use a crude phrase, an ugly pig, because it's been designed as a light configuration within an overlay of residential development. And the second is the potential to constrain, say, thoroughfares and so forth. But I guess Mr. Hansen's right, that really there are risks either way. I mean, the risk that we're worried about is that the site has value as a residential development area potentially and is suboptimally used simply because that's the lowest hanging fruit for the developer. And to some extent, Mr. Hansen is saying it is a rather long bow to draw that if we rezone it, they're not going to take advantage of that zoning but just box on, which I understand, because I think the Mansell, immediately it's rezoned, it has a higher value, which you would be unlikely to stare in the face of. But in terms of overall design, I guess there is a walkway now established along the edge of the state highway that may wish to be accessed. And I guess the point there is, well, you won't get any better access than rezoning it, because if the current development goes ahead, it'll still have those consequences. Yeah, those are the sorts of balls in the air in my mind that we're trying to deal with.
Yes, I think, sir, if I may, the Duncan Cotterill memorandum and the work that they did was actually really important, because it showed in my submission that further development of the Mansell site, rather than preclude, actually starts to unlock access and services provision into that area by providing the future linkages. So at the moment, Coast Street is for a legal road part of the way. For the Otihonga Estate subdivision, which is the consents that are under appeal currently, the proposal was to extend that road further into the Mansell site, so further north. But it doesn't go the full way. There's a couple of sites in the north that are accessed via a right-of-way still, which is a bit of a gravel track that the panel would have seen if they had gone on your site visit up there. Yeah. So Mr. Mansell obviously will speak to this in a second, but once you start to look at how you develop the Mansell's site under general residential provisions, it becomes necessary to extend all of Te Iko Street so that you're getting sufficient access. So you're extending the street right up to the end of the right-of-way, and that again will provide, it doesn't just provide the opportunity, because the sites to the north already have those legal mechanisms in place to allow for access, but it does provide for easier legal access and the provision of services down that extended Te Iko Street, which would become a legal road and that the council would have control over. So maybe in response to the first question, maybe it not being, it doesn't preclude it, actually maybe the sort of initial, it will kick off development in that area if it is rezoned, rather than precluding it.
Yes.
That's one point I was just wanting to make sure you realise the differences between the two things.
Yeah, so in our site visit, we went along that driveway until we got to the house at the end, guarded by a dog. And then we came back and went about halfway along that map in an extra one and went up on the ridgeline where we observed a lot of rabbit activity, not much fun.
Yeah, but there's a large population of that land at the moment. Unfortunately, it's not people, but we hope it will be at some point. There's a lot of...
But are you saying that the easements run along that entire length of the driveway and therefore effectively would have to be formed as road to provide development?
That would be formed as road to be able to provide better access to those lots at the back, and also have the flow-on effect of providing legal access to, or formalised legal road access to, those sites that just currently go up the gravel driveway, who are owned by other property owners at the end.
Right.
So
would that vest as, how would that vest as road if it was subject to a private easement? So those landowners, let's say, they didn't want to give up their easement, how would that work?
Yes, well, the applicant is, or sorry, the submitter in this case is currently dealing with the easement extinguishment arrangement. So they have entered into a deed with the landowners to extinguish the necessary easements and revest in the council as a legal road. And part of that process is done for the proposed extension for the Otihanga Estates process. So there's a deed, and then as a result of the deed, then the property lawyers do the conveyancing around that, and then that can vest in council at the necessary time. The owners of 68 Te Iko Street, so that's the Keene property and the Mackay property, are well aligned with the Mansells, and we have probably, and I'm sure Richard can speak to this as well, but we don't have any concerns about them wanting to sign off on getting illegal access and getting a road past their properties. There's sufficient benefit to them if we were going to extend the road that way. So while that, I think, is, whether it's realistic, it is something that the panel should be concerned about. I think that obviously the process to extinguish those easements and for the land to vest in council is sort of, with respect, a private matter between those parties, and as the chair will know, there's that ability to apply to I think it's the High Court, to get any easements extinguished where those parties cannot agree how to do that by the court.
Yeah, so I suppose Mr. Hansen would still say that a residential zoning is likely to be a catalyst in the same this application is for that, but the odd thing is that the other sites may subsequently benefit from a residential zoning through some other process when this is a perfectly acceptable candidate as well.
Yes, that may be the case. Just to finish the point on the easements, I think it's the Mansell land that carries. So it's the Mansells that own the land that has the right-of-way on it, where the right-of-way needs to be provided to those other property owners for access. So when you're looking at whether the land's revested, into council and becomes a legal road, we're not saying that access would be impeded in any way. It would actually be improved. So
oh yes, that's right. Although whether you can still take someone's easement away or vesting without some sort of process, I know it's a little bit theoretical. If they're getting effectively the same level of service or better, it's not going to be a problem, likely to be a problem.
And we have the agreement for the first part of the road that is to be replaced. So there's no issues that we're aware of that would preclude that going as well as what the other one had. So that's one point that I had, and I'm just a bit conscious of time. The other point that I had is that obviously last time we had spoke to the panel, the chair did have some questions around whether a structure plan could be drawn up for this site. And I think, I know your views sort of change as you go along and consider information, but one of the questions was, well, perhaps the consent submitter could go away and draw up a structure plan, and that might be a good solution, and may mean that we're able to consider the rezoning rather than not. We have made those efforts because I'm conscious there's no appeal rights in this process, and sort of heartened by the indication from the chair that we are almost there, and the council's suggestion that we're sort of 90% on the same page. We did try to meet with them just to see whether we could get an indication of what that structure plan might look like from the council's perspective for the Mansell site. The reason we have tried to do that rather than coming up with one of our own is that it is primarily due to the fact that the council wanting to maintain those linkages through to other properties rather than what the Mansells, we don't need that to develop the Mansell site. So I was a little bit nervous. I just wanted to tell the panel that we had seriously considered it, and we did try to progress that. Council weren't willing to meet to discuss that at this point. If that's something still on the agenda, I would very much like I guess a direction from the panel, just seeing whether we can confer with council on that and agree. I just wanted to say that it wasn't something that we have purposely ignored. Our position is it's not required, but if it is, we're more than willing to entertain those possibilities and have those discussions with council very quickly to make that happen, so that there's something acceptable to come back to the panel on that issue, if that's how you think.
Yeah, well, we'll come back to you if there's any minute that follows from that, but I'll just give you an authentic response from me only, recognising it's only if there are no opportunities and constraints of significance that are foreclosed, that's a significant reason why the lack of existence of a structure plan may not give us any reason to be worried. But that's not true of every site that we've seen, where a whole range of considerations would impact on the opportunities and constraints situation. And I'm not going to talk about those because they're now within our deliberations. But so this is a little bit distinctive in that regard. But I totally understand the council's reluctance not to get into structure planning through this plan change process because, well, Mr. Holland's on the line and he has a very strong views about good process and forming a structure plan to work well needs community consultation and engagement. And I agree with that. So I think if structure planning is required, it's not the right place and time to do it here. So if we were to form the view that a structure plan was required here, I think that might be a fatal flaw in this submission. But for myself, I'm not sure that I take that view.
No, we certainly don't, sir. It was just out of an abundance of caution because obviously there's no appeal or mediation to work these things through a little bit later. So I didn't want to leave the fact that you'd made a very strong indication in the previous time we met to discuss this, that may be something we should be considering and that we hadn't. So
I did actually propose that at the end of the day, which was hearing private zonings, and Mr. Banks we had concerns about process and secondly time, and we heard that.
Okay.
But your site, I think, well, at least from my point of view, would only require structure planning for linkages, which I think Mr. Hansen is saying you probably would get through the normal consenting subdivision process and the usual exchange through the discretions that exist in there. They're not very substantial because you've got the roading connection, the roading linkages look so fine. It's more the other modalities of transport that we were interested in. That gives the flavour. I mean,
yeah, with the road also comes the shared path, sir. We've got the plans for Te Eco Street, so there wouldn't be, and it's got a footpath, quite a wide footpath on it as well to assist with some of those linkages. So there would be every expectation that would be continued in the same form down the rest of the street, and linkages looked at through the site, because that's one of the criteria for the restricted discretionary activities for the transport concerns. So I'm venturing into planning now, so I might leave that for Mr. Hansen to discuss, and unless you've got any more questions from me, perhaps we could move on to Mr. Mansell.
Yes. Hello, Mr. Mansell.
All right, good afternoon. Phernne, or Ms. Tancock, sorry, has asked me to just comment on the panel's question of would we go ahead with this, or would we just merely end up with an ugly pig development? Basically, if I started at number 9 in my submission, basically we've done all the hard work, and to get to the next stage, and we've done all the environmental stuff and the roading stuff, and that's all the hard stuff. We'd be silly not to keep going, as I think you've mentioned. But my family are not in the habit of doing things half-heartedly, and we'd certainly be looking to maximise our return out of this, and to probably triple the amount of sections, but possibly not triple the amount of costs. We'd be stupid not to do it. I've talked to my brother, who's one of the appellants, one of the submitters. Too many hats, and he's firmly of the opinion that we will keep going if Plan Change 2 allows us to, and design a residential subdivision. It's as simple as that. We're in it to make money, and we'll make more money by doing the full residential development. There'll be the obvious restrictions of that council impose upon us in terms of design and such like, but it's almost certain we will make more money by doing the full residential.
And if you didn't, if you put it to market, you'd take a price which would reflect the highest and best use, which is residential.
Absolutely, yes. But I'm got nothing else to do. I don't think I'd put it to market. You're more likely to make more money yourself.
Yeah. Okay. Well, that makes sense to me. I mean, it is a risk, but it can be. We shouldn't start at shadows. So should expect people to behave rationally, and if they have the incentives right, they probably will.
Yeah. It's the sort of thing my family have been doing since the 70s. My father started out and has done multiple subdivisions, buying land, dividing it up, selling it, making a profit, and then moving on to the next one.
Right.
So it's what we do.
Right. Okay, so that's helpful. Is there anything else you wanted to say?
Cool. I don't know. I don't think so. There was you mentioned a path beside the expressway. There's actually no path along the western side of the expressway at that location. It's all on the east.
Or a bridge across to the other one, or?
Oh, we could. That would be massively expensive and I think very difficult to consent.
There was go over the other side.
Sorry.
I thought there was existing infrastructure that you could go over the other side or something like that.
You get out onto Otahanga Road and there's an existing pathway that leads to the western side of the expressway. On our side, or the side that we're developing, there's no, if I consider Otahanga Road to the river track, there's no track on that side. Whether or not that would be joined up by subsequent development through particularly Paula Keen's property, which is 68, I think, Tieko Street. That would be up to her, but certainly within up to her boundary, we're more than likely to have put a pathway because it's not inconceivable that she will want to move on from where she is at some stage, and the highest and best use will be residential, and then all the pathways can be imposed upon.
Yeah, Commissioner Black, can you recall what infrastructure there is on the western side of that expressway? You are an expert on this.
Well, I hadn't realised actually afterwards that the walkway, the pedestrian cycleway is, of course, on the eastern side at that point, isn't it? Along there, in other places it's on the western side, but it's not at that point. So I don't. There's no. I mean, it's just runs the farms, etc., just to run right up to the expressway, don't they? There's no other.
If perhaps I could clarify, south of Otahanga Road, the walkway cycleway is on the western side. So, and then at Otahanga, you go underneath the expressway, then it goes on the eastern side, north to the Waikanae River. So the site's ideally located in that. If you want to go south, you have two options. There is actually an existing pathway along Ratanui Road to Mazengarb, existing walkway, cycleway along there and past the actual site. And there's also then, or you could go and use the expressway, cycleway, walkway, which is on the western side. So there's easy linkages to both of them. If you wanted to go to Waikanae, then you'd just go simply under the motorway onto the eastern side and then cycle up through there.
The big impediment to a cycleway on the western side is the wetland, which goes right up and over into Transit's land.
Yes.
I think it would be more or less impossible to, well, not impossible, but hugely expensive.
You'd have to bridge it.
Yeah,
you'd have to have a bridge similar to what they've done, I think, north of Pekapeka. There's a few bridges over a few little sort of waterways there that they had to build, but you'd have to do that. So it's not impossible, but it would be expensive.
Right.
Yeah, so it's not far to actually get onto that cycleway, is it? That's what
you're saying? No, not at all. Yeah.
No,
right,
I can see. I'm just looking at Google Maps, of course, and you can see how you can just get on it.
Yeah. And that was part of when we did the resource consent application. The council was keen to understand from a commuting perspective whether cycling was a possibility, and it clearly is.
Yeah.
And as I said, you can either go on the expressway or to go south, or you can stay on Mazengarb and go through to the Paraparam beach. So, and it was 4 kilometres or something, 15 minutes or less. It was all really within good location. Yeah.
Yeah, it's pretty connected, isn't it, Kapiti, for cycles?
I could also point out that the two blocks of land that are serviced off the right of way that is on our land, one of them has an application for a resource consent to subdivide already, and some of those sections are on the market to sell. And Paula Keane has, when we first started the process about 2017, I talked to her and she said that she was interested in being part of our development, and we, for a very short while, included her land in ours, but it became difficult to coordinate everything, so we just chopped back and just did our own land. But she's certainly interested in selling, and you know, if we provided services and roading things right up to her boundary, I think it is only going to enhance her ability to do that.
All right. Well, that's probably at the moment we sort of observed you were farming more rabbits than stock, so
Yes, my parents moved off there in probably 10 years ago, and it's only really been grazed by horses and a few cows since then, but the rabbits have taken over. The expressway just opened up a whole lot of rabbit country, and it's been a huge problem up and down the coast because of it.
Okay. All right. Well, that's fine, Mr. Mansell. Thank you for that. So I suppose logically, where do we go now, Ms. Tancock?
Well, I was just hoping we could have a very quick chat to Mr. Martell, who's popped up in the meantime. And he's filed I told him it needed to be a one-pager, and it certainly is a one-pager memorandum from AWA. So I'll just get Craig to Mr. Martell to speak to that, and obviously he's available for questions if you have them. Then we can head on to Chris.
Thanks, Ms. Tancock. Yeah, I mean, I suppose from my perspective, and particularly considering the more detailed assessment of access, but even before that, we had in paragraph 30 of my evidence highlighted that a change in density would require some updates in terms of assessments, and we've got no real concerns that at that time, understanding what might happen further out from that can't be allowed for in the normal course of design. And so that's what's reflected in my memo. Yeah, and I suppose the only other thing is just, that's a pretty normal process. I can see the argument for structure planning, and am a fan of it. I think in this particular situation, all of the requirements that we would have in terms of access from an infrastructure perspective have been met, and that can, and that can be implemented through the development that's been proposed.
Okay. Do we have any questions, commissioners?
No.
Thank you. All right. Well, that's pretty simple, Mr. Martell. So we go to Hansen. Now, Mr. Hansen, we've read your evidence, so I just have a couple of questions. The first question is, on our site visit, I thought the wetland was a little bit, the one on the northern side adjacent to the expressway had a little more ecological values than the ecologist claimed. It was a reasonably good example of a dune slack wetland, I thought. But your point is that would be adequately picked up in the whole regional consenting phase through even if we did do the consent. So we're not against policy 50-55 or whatever it is, in the sense that we haven't identified in the course of rezoning the opportunities and constraints adequately in ecological terms. It's a question rather than a statement.
Okay, I think as you know, Mr. Goldwater, who was the expert ecologist, appeared at the hearing via a video link, and he confirmed that the assessment that wildlands have done of the ecological values still applies. And I think that the key thing is that we would still, although there's no detailed design yet of a more intensive residential, the intention would be to continue to maintain all those buffers. You'd include the lizard habitat which went around that wetland you were referring to, so there's even more a buffer again. That wetland has changed its structure and its function. Again, I'm not an expert in it. That's what he's advising me as a result of the expressway. And so it's primarily used also as a retaining from road water from the road as well. Right. Interestingly enough, it was large. It goes to the other side. If you think of the highway at the moment, on the eastern side, there is some wetland, some large ponds there, and originally it went right across, and so they've obviously cut it off. So hydraulically, it's changed as well from that perspective. But it's and I think Richard can confirm his observations anecdotally, as it's got less water in it than it used to have. Even so, some of the effects of the expressway may be affecting it that way. The key thing was that from ecology perspective is as long as we put the buffers in, and as long as we pest plant controlled, etc., and maybe some replanting with appropriate species, they would survive and flourish on their own without much management. And right. So that's the general principle we've taken to the 4 wetland areas that have been recognised. Right.
Now, the other question I had was in relation to your response statement of the 20th of April, our request for additional information. So this is the part that you're not answering the 2 questions we postulated, but you're actually dealing with the provision changes that you wanted, is that?
Oh, correct. Yeah, so my evidence was in 2 parts.
Yeah.
And the first part was all about the site. The second part was the other parts of the submission, which were basically saying we would like to see some wording changes to the objectives and policies to better reflect the MPS UD and the RPS plan change. And at the hearing, I think you indicated it would have been useful to have words so that you could you could see what we were proposing, and so that's what that is. So if you read it in parallel with the second part 2 of my evidence, you will see I've raised the issues and then said that they need to be changed. This is a demonstration of some of the suggested wording on how you might change them to take on board the submission points that were raised.
Yes. So my question about that second statement is to what extent is that I mean, those changes, they fall away if you just rezone it. The other side of that coin is, what extent is this just a make weight to support your current contest over the resource consent? Do you know what I mean? It's like, I wasn't sure why we should be getting into this. Seems to be looking towards development, greenfields development of future urban, which was likely to be a future plan change of the council to look at. It's been, because of the change in the Housing Supply Bill and the Act, they've had to deal with this intensification question and then put the greenfields on a back burner, and that might involve a future plan change. To what extent is this really preempting that?
I think the purpose of this side of it was to try to get the plan change to align better with the UPS, the MPS UD. And so, I mean, the Mansells have also involved in the PC1 that's to the RPS as well. So they're looking at bigger pictures. So this is not specifically about a site, a particular site as the rezoning is. This is about what might happen in other areas as well. The Mansells may have interest in other areas too in the future. So this was really trying to get an alignment with better alignment with the provisions. Bearing in mind, and I did mention in my main statement of evidence that the current district plan, the way it's written, it was drafted back in 2012 and has a consolidation approach that was held at the time for many years by Counsel. Trying to move away from that, this is an opportunity to, through this plan change, to take a much broader approach to the urban environment as it's now defined, and what the objectives and policies that are driving future applications would consider.
Yes, I guess my problem with that is I'm not saying that philosophically it's wrong in planning terms. It's just that the rezoning naturally arises as sort of incidental changes to zoning that sort of gets swept up with the otherwise major function of plan change 2, as opposed to a broad scale greenfields development regime. And this type of proposed wording, and effectively, I mean, the centre's consolidation approach will have to be relooked at, but the form in which the response at which the council needs to do that probably needs to go through a council process to decide exactly how they want to formulate that. Do you understand what I'm saying? It's like I don't want to hijack the PC2 process to an extent where we're actually telling the council how to actually do its greenfields.
No, I understand what you're saying. No, these changes here are predominantly related purely to the changes that PC2 is introducing, but wording them in a way that is, I as a planner consider as much more consistent. The purpose of PC2, as first stated, if you read it, is to come in line with the NPSUD and to implement policies 3, 8, 3 and 4, etc., and meet its functions. So I think what we're trying to do here is to get that wording to achieve that better than it does at the moment. So it's in the context of PC2, not in the context of greenfields or development further down. That's what these, and that's why I split my evidence into 2 quite distinct parts. The first part dealing with rezoning of a piece of land that would go to general residential, etc. The second part is to do with the broader what PC2 is trying to achieve. And what I'm saying, in my view, and the Mansells are saying in their submission, is it needs to go further, and that's what this was suggesting. So it's within that scope.
Well, I suppose
now, at the end of the day, if you agree or not, it's another matter. But it's trying to help to get it read better, basically, and be consistent with the NPS. That's really where it's coming from.
Yeah, well, I understand some of those would fall into that category. I think the Aotearoa objective is pretty much
yes. Oops.
Sorry,
I missed that, the Aotearoa objective.
Yeah.
In terms of the future. Sorry, someone's trying to ring me, and looks like a sort of supporting specific and trying to make some decisions about the future of Aotearoa that I don't think we're really in a strategic position to determine.
So, sorry, could you? I'm trying to find
1.7.
Exactly.
It's paragraph 1.7 of yours.
Okay. Yep. So that's the explanation, not the policy. Is that what you're referring to? So simply, what the point there was, Aotearoa was characterised as being low density residential, and all that those wordings in the explanation, not on the policy itself, but the explanation was trying to say was that Aotearoa itself is broader than just low density residential. That was the distinction that was being made there.
think my view on that one, just that particular one, was while the other ones do actually just take wording straight from various places, you know, the MPSUD.
Yep.
This
Try
one
to be consistent.
That's right, and I can see why you might suggest that as bringing it consistent. But I did feel the Otahunga one, it was perhaps a step further than that, as did the chair, in saying that that it's suitable for investigation for greenfield urban development, which doesn't. It's specific as if council has made that decision.
Yeah, so that was based on the Section 32 evaluation report that came with PC2, which the Appendix N clearly identified the wider Otahunga area as suitable for investigation for greenfield. So I'm not picking words out from anywhere else. That was part of what was supporting documentation that came with PC2.
Yeah,
but
I did. It's
simply a high level opportunities constraints analysis. It's not.
No, absolutely. Yeah, absolutely. I understand that.
I think council is going to probably do a future plan change to address greenfields development and start implementing whatever the final form of the regional policy statement is to address housing in a logical, coherent way. And I don't want. I'm attracted to this site for its other qualities, is for a reason. I'm reluctant to go into sort of wider planning of that nature, given that the primary task at the moment is to nail down the impacts of the new residential standards. And so,
yeah, if I could just clarify, this was actually more about defining Otahunga. And so when Otahunga is mentioned, in general terms, it's been identified as just the urban area, whereas Otahunga, in terms of Section 32 evaluation that was supporting it, actually was talking about OH01, which is east-west of the highway, large area, and that's all that was that's all we were trying to do, was to get Otahunga as a place better defined than just a low density residential when it isn't, or when it wasn't, in terms of the Section 32 supporting documentation. That's all it was, nothing more. Not trying to, you know, if you see what I mean,
But I think it could take a life of its own, and I'm just conscious that that given the strength of where the regional policy statement is going, new greenfields areas generally are going to have to be quite well planned.
Again, don't disagree with that. It's simply, as I said, it's in an explanation that's defining Otahunga, really. That's what we're trying to do. The wording doesn't suit, that's fine, but the key point is that Otahunga, as we're looking at it now, is more than just the low density residential area. That's the point that we were trying to make. And the office disagree. They recommended it be declined, and they said no, it is just low density residential area. So there's a question there of what Otahunga is an area that's been, that really is the point that we're trying to make here more than anything else.
Well, yeah, except if you look at, say, 1.12, which is a change to a policy at item 3, you're saying the subdivision and development we managed across the district to provide for a variety of densities in the general residential zone and the urban environment, including current non-urban areas identified for investigation for future greenfield development. Now, what that suggests to me is we're elevating Appendix N, which is a very high-level opportunities and constraints analysis, into something which will lead or inform assessments of applications. Now, to me, that type of statement, if made, could have all sorts of unintended consequences.
Yeah, to counter that, I would say though that policy 56 of the RPS, if it is amended according to the way it's proposed in there, clearly identifies that it should be for sites that are not sequenced or even future as well. So they are, what it basically says is that all sites should be considered, even if it's out of sequence or hadn't been on the radar, as it were. And that's why the idea of them being identified for investigation could be in a site that is appropriately brought forward under the RPS. Now, if that stands, that's what that wording was really reflecting back. And I think it was back to the point about, is this implementing the policies 55, 56?
Yeah.
So there is a logic there from a planning perspective. I was trying to bring through. I
still come to the point that if PC2 is implementing the changes to the residential density standards and policy 3 and 4, it's not naturally dealing with that wider greenfields issue in quite that way.
Well, this is where the timing of it's been interesting, isn't it? In terms of PC1 to the RPS has come through also implementing the MPS, and the district plan is going to have to respond to that as well. Now, the planner took the approach at the time that it wasn't in a far enough through the process, and so they wouldn't. I took a different view on that, and that's come through here. Now, that's obviously from the Commissioner's perspective, that's something you'll be grappling with as well, no doubt. How they connect together, and you may not be in the benefit of having any further movement on PC1 before you make your decision. I appreciate that, and for that very reason, you might say no, these words aren't going to go in there because you don't know where the PC1 is going to be there. I appreciate that as well.
Yeah, thank you. But I do think the spirit of picking up sites that have potential along the way, if they're in scope and there's no logical reason to ignore them, is part of the reason why we're studying the Mansell sites.
Oh, absolutely. And again, this is beyond that particular point. It's the broader things that were being addressed here. Yeah.
Okay. I'm sorry, I'll hog the show. Do you have any questions?
Well, the 37 Tancock, Mr. Hansen, because it's referred to in the the plan. It's the orange area, and it doesn't have access to legal road.
Sorry, let me just. I've got that memo open amongst everything else.
That's referred to in the legal the memo from Duncan Cottrell, I think, and I think you refer to it as well as not having.
Oh, 37. That's correct. It's an interesting situation, whereby it has legal access. It has the easements to the services, etc. But it does. If you looked at the figure, the color coded figure that was in the Duncan Cottrell, it does have it gets to a right of way, but not. It doesn't seem to, for some reason, have. It has a legal access to it, but doesn't seem to have formed or something. It was quite strangely worded, and I've worded it exactly as, and so what I've put in here is exactly as the Duncan Cottrell. So it's got easements and it's got the benefit of a right of way. So for all intents and purposes, the right of way can go in there.
It can have it. Can achieve it. It just hasn't got it currently.
That's right. It doesn't have it currently, but it has what's called the benefit of a right of way with it.
I saw those words. I wasn't really quite sure what that meant.
They were the words used by Duncan Cottrell in terms of describing it. So it's so I was very careful to use exactly the same wording because it obviously means something to the property law people.
I can check with Duncan Cottrell, but I do recall when I spoke to Ms. Mitchell about this, who provided the advice, it was the fact that it was on paper, there was a right of way, but that it hadn't been, so there was no obvious access if you look at that piece of land, so it hasn't been developed, but that there is an existing right of way that could be used or relied upon for that site to get access in the future. But I'll that, but that was my understanding.
Yes, because it said all of the properties, with the exception of 37, have access to a legal road. So it doesn't mean it doesn't have the potential for it. I suppose it just hasn't.
And it would be, and I looked at the map a lot closer. Potentially, if you look at that map, the very southern corner almost like touches the end of Tico Street, which is a legal road. That's where it finishes there, but it doesn't seem to have a boundary against it, if you know what I mean. There's another right of way that goes up to the blue site, and so that's why I thought it was perhaps carefully worded, because it appears to me, looking at just the way it is that Tico Street finishes, and it's only the very corner of that site that potentially touches it. It's not wide enough for legal access, but it must have an easement type arrangement over it, but doesn't necessarily physically touch it, if you see what I mean.
Yeah.
I mean, the blue site is in a similar sort of situation, but it does have a formed access that goes down to Tico Street, and you can see the services run up to it. So yeah, I think it's just I don't think it's an issue at the end of the day in these sense, but it was just funny. It was worded strangely.
Yeah, maybe it's just the wording, just to get clarity on that would be good. So wastewater is all on site, is it? Wastewater is, it's not articulated, because you talk about stormwater drainage.
There is I think Craig Martell included in his evidence the wastewater and site systems and all that, and they're close to they're up to the end of Tico Street, but they are Ratanui Road, so there is a need for wastewater to be taken from the site in Otahanga and connected up in it, but it's not far. It's not far at all. It's all being looked at as part of the original proposal.
Yeah. I mean, I feel like the chair. I felt the same. But there's been a lot of work gone into considering the site, considering all of the constraints and the opportunities, and doing the planning that got you to the application that you've got resource consent for, that's subject to appeal. So it is a different case from a lot of the other parcels of land that we looked at, because it has gone a long way down the track to considering how things might fit in and look like there. If you did get the rezoning of the land, you would, I mean, at a high level, you're going to be keeping obviously the same kind of, well, you obviously got your wetlands and you've got the basic structure of it. And I noticed that Dave Compton Mine also did a fairly high level look at. Very high level. Yeah, so you'd be back to the drawing board a bit, wouldn't you, in terms of looking at how it would actually lay out. I mean, I imagine you'd have the same buffer to the expressway, and you'd have the wetlands and the landscape features, etc. I mean, the council would be requiring that of you. Oh, that's right. And there's another thing to remember, and I put in this in my evidence, my supplementary statement that I put in here, that there is also the new design guide that's been introduced by this that needs to be for urban development. It needs to be considered as well. So there are other things that would have to be overlaid on anything that's done from a detailed design point of view. But it would be back to the drawing board, really. The opportunity would be, and as we've discussed, there's likely to be new access to the further to the north than the current one that they consented, which would take that. There's a whole lot of things that would have to be looked at, definitely. Yeah. That was really what I wanted to discuss. Thank you. Cool. Thanks.
Anything else, Rob?
Not for me.
All right. Well, I think unless that's all, I think there's one item of information that Commissioner Black has asked for. Other than that, I think we're okay.
Brilliant. Just confirming that's to confirm the access arrangements for 37 Tico Street.
Yeah, just some of the wording's just a little bit, if you could just clarify what that wording means.
Absolutely. I'll do that this afternoon. Thank you very much to the panel for your very detailed consideration of the Mansell's rezoning request, and obviously the ability to address you again this afternoon. I think it's been, from our perspective, very helpful to be able to clarify those things. So thank you for the opportunity, and good luck with your deliberations.
Yes, we haven't actually formally. Yeah.
Is that probably a little bit over optimistic on my perspective that we won't get another minute?
Yes. Hearing, I just want to make that clear, because depending on what the council comes back with, we may have some other things to deal with. But thank you for that, and we are going to give all the matters we've seen consideration, which is not to say the report's going to require a jack to carry around, but we are going to give it detailed consideration.
Thank you, sir. And of course, if there is any further information that we need to provide in relation to the rezone request, we're very happy to do so.
All right. Now, Alfred, are you there?
Yes, I am.
Is it technically feasible for us to now go into camera as a team, because we wanted to take stock of where we are and where we need to track? Is that possible? And obviously we don't want that on YouTube.
Yeah, absolutely. I'll take off the YouTube now, and whoever want to stay in this Zoom call can do so.
Right. Well, that'll just be our team.
Well,
Thanks for.
Thank you very much.
Bye-bye.
Thank you. Bye.
Bye.